All rise. The Court of Appeals, Division 1 is now in session.
Good morning. Please be seated.
Thank you.
We are here for oral argument in cause number CV19-0760, Marley Mauvis versus Scottadale Christian Academy. Council, please feel free to take your masks off so you're 6 feet away from each other and 6 feet away from anyone else. I think you're safe. I can't guarantee it, but if you would like, please feel free to take your masks off. These proceedings are being video and audio recorded as well as live streamed, so we ask counsel to please identify yourself and your client at the beginning of your argument. Each side will have 20 minutes. Appellant's counsel is responsible for watching the clock to reserve any portion of that time for rebuttal if you desire. We have read the briefs. We have conferenced this case. We are familiar with the facts. I'm going to ask you both to argue from a seated position so you can use the microphone and we can hear you. At this point, counsel, please proceed.
Your Honor, Robert Greer on behalf of Marley Mauvis and her children. May I first say how grateful I am to be able to talk to a judge face-to-face after 6 months. It's really nice to see responses and be able to talk with a person rather than on a monitor. In this case, the decedent, my client's late husband, Gerard Mauvis, was without dispute a business invitee of Scottadale Christian Academy. The relationship between the possessor of land and the business invitee defines the duty. When he was struck by a car,
well, to be clear, though, it establishes the existence of the duty, but it doesn't define the duty, right? Different invitees might be owed different duties depending on the nature of the premises.
Well, because the duty is reasonable care for the safety of someone on the premises, that's pretty generic.
Yeah, we don't know what that means, and the law doesn't tell us.
That's true.
Okay.
The details of how the duty is fulfilled or not fulfilled are the things that become factual matters and things for a jury to determine. But a trial judge can decide duty is a matter of law, certainly, but cannot decide whether, at least in most cases, cannot decide whether the duty was discharged by some act or another act. Those issues are to the jury. The issue in this case causes us to read Nicoletti more carefully than we've ever read it before, because the duty was that SCA, Scottadale Christian Academy, had an obligation to use some care to avoid or prevent injury to him. The extent of the care, how that was discharged, is a different matter that the trial judge cannot decide on a motion to dismiss. The dismissal of a complaint based on the duty rubric is pretty extraordinary. The proper rationale is that any duty that SCA owed to Gerard Mauvis was extinguished once he left the premises. Although the judge agreed that as a matter of Arizona law, the duty extended to areas outside the premises, she decided that once he crossed Tatum, not within a marked crosswalk, that was a impliedly unpermitted activity, ergo there was no duty to begin with. In essence, she decided that because she felt the decedent was comparatively at fault, that there was no duty to him because he was really at fault for walking on Tatum Boulevard. Nicoletti does not compel that result. Nicoletti dealt, of course, with movement of a business invitee on the premises itself. When she trod across a raised planter on the perimeter of the property en route to her car, she tripped and fell. The court, Justice Gordon writing the opinion, held that because that was not an area of invitation, that the duty did not extend to that area, and therefore Westcourt did not have a duty. That was in 1982.
Do you think that case would be decided differently after the adoption of comparative fault?
I think that I think the approach to it would be different. In other words, I don't think that the restatement principle upon which Nicoletti was based, that you only have a duty if someone goes to an area that they're expected to go or they're invited to go. The examples from Pope from 1923, I think, are probably would still inform a judge on what the duty is. What is different is the effect of Markowitz and Coburn and actually Udy and the Basha-Stevens case all talk about warns judges not to go into the details of conduct when deciding a duty, because the decision in Nicoletti said that Westcourt does not have a duty to give someone the shortest route to his car. Once that is said, they're talking about how the duty is fulfilled. In other words, you've got a duty of safety, but how that is fulfilled is a matter of fact, but we're going to decide it right now. I think that's the part that would change.
So when you're talking about the quality of the landowner's conduct, that is not duty, it's breach.
Yeah, that's true. That's my sense of it. I mean, comparative fault didn't really change how one defines duty or contributory negligence. The legal effect of it is quite different, of course, but I don't think it really changes what the duties are to begin with. I think it's still based upon relationships.
It can't really change the duty, can it? Because we have a constitutional provision saying contributory negligence is always for the jury.
Yeah,
So, I mean, if we tried to include that in a doctrine of legal duty, we'd probably be running afoul of the Constitution.
I think so. I mean, one of the odd things about Nicoletti, it relied on a couple of Illinois cases involving off-premises injuries. And in Illinois, a court could decide contributory negligence as a matter of law. And that's what they did in those cases. So it wasn't read that carefully when the opinion was issued. The subsequent cases that this court decided in Udy versus Calvary Corporations and Stevens versus Bashes make it pretty clear that what a plaintiff is doing, what a business invitee is doing off premises does not modify the duty of the possessor of land. 2 points that in the Stevens case. The occurrence of Stevens' injury beyond Bash's warehouse premises may be relevant to whether Bash's acted reasonably under the circumstances. It does not mean, however, that Bash's owed Stevens no duty of care. I think that is determinative. Once the duty possessor versus business invitee is established and the reasonable care is established, the details of it have to abide a jury decision. And the fact that the court felt that that was really fell under duty alone, that's what brings us here, and I think that's error. Now, I can repeat myself several times over, but that's the essence of the argument, and I'll reserve my time.
Thank you, counsel.
Thank you, Your Honor. This is Elizabeth Fitch appearing on behalf of Appalachia Scottadale Christian Academy. My plan today is to focus on the framework for how this case needs to be decided. I have spent a good deal of time and a lot of paper. I've destroyed many trees going through the 30-plus cases that are cited in the briefs and gone down some rabbit holes. Is a lot of case law out there on tort law and what the duties are. What I've tried to do, and what I'm going to talk about today, is I have synthesized that and tried to reconcile that body of case law, because Judge Mauvis did not have the benefit of the Quiros case, and we do. So taking that into account and all the other cases, I've tried to reconcile it and synthesize it down so that we have a cogent framework in which this case can be decided.
We've been waiting for somebody to do that for 30 years. Well, thank you.
Here, here.
We can try. That's my hope. And I certainly do bring
great
my own
setup.
perspective. Pardon
Yeah,
me?
it's a great setup. I can't wait to hear the argument.
Maybe I've overstated my case here. I have tried to do that. I think it's important for us to do that. And the Arizona Supreme Court and the Court of Appeals and all of us who've been practicing for a while have been wrestling with the concept of duty for years. And it has evolved over time. And Gibson and Quiros, as quoted, brought a sea of change when we're talking about duty. But there is a clear established framework that we can look to in order for this decision to be made today.
Maybe one of the cases you could address, though, is Markowitz, because as much as Quiros and Gibson sound different from Markowitz, they both pay homage to that case, and it seems to me that the rule that the court establishes duty as a matter of law and the jury decides the content of the duty has been pretty clear for a while, even though it's been stated in very different terms. Would you agree with that?
I think that what Gibson and Quiros do with Markowitz is recognize that position, but also recognizes that was based on foreseeability. And Markowitz, when you really break it down, is based on foreseeability. And Gibson and Quiros specifically stated that the law in Arizona is no longer that the law is now we have to disregard foreseeability, and duty is based on two things, either public policy or a special relationship.
All true. But while Gibson and Quiros may have thoroughly rejected Paul's graph, I'm not sure that they thoroughly rejected Markowitz. Because Markowitz did acknowledge that foreseeability was the linchpin of breach, and said breach is reserved for the jury. And I'm wondering if that's not where we are today.
I think that we are there today in the sense that foreseeability does go to the issue of breach, and foreseeability does not go to the issue of duty. But when we're talking about duty, the Quiros and Gibson case, and the totality of the cases, when you look at them, there are only two paths on duty. It is either there is a public policy reason to impose a duty, or there is a special relationship. And that special relationship comes in three forms. Those three forms are contract, common law, or the negligent conduct of the defendant that imposed a duty upon that defendant. Those are the three paths. I have not heard from the appellants that they're suggesting that that the duty here should be imposed by public policy. So I'm going to fast forward through that. If you want to hear on that, I'm prepared to address it. But I think what we're really wrestling with is this concept of special relationship in the context of a landowner to a business invitee.
Right. And do you agree that the plaintiff in this case is a business invitee?
I agree that at some point he was a business invitee. I disagree that at the time of the accident he was a business invitee. He was not.
So you're saying that in order to be a business invitee, the decedent here had to actually physically be on the school premises?
In order for that particular status, yes, that is exactly what I'm saying. There is a distinction between status and that special relationship and conduct on behalf of the defendant that extends the duty beyond the property.
Well,
That
yeah.
is a conduct, not a status. The status we have here is either invitee, licensee, or trespasser. And I think the case that's most important to address that and that recognizes that is the case, I'm drawing the blank on the name, but the licensee was a social guest at a party. He left the party and he proceeded to walk across the street where he was beat up. What was important about that case is the court explicitly recognized that when you leave the property, your status changes. His status changed. And
Okay,
that is,
so if I set up a store that's going to sell Teslas for $10,
I'm there, by the way.
you are, but be careful before you accept my invitation, because I set it up so that the only way for you to access is to cross I-17 on foot. Are you my invitee when you try and make that journey?
No. What you are.
Really?
No, what you are. You are a member of the traveling public. You are a pedestrian. If you're walking, you're a pedestrian. You are a member of a traveling public. And that is a different duty that a business owner might owe to you.
But it is a duty. Would you?
Yes, it is a duty.
So are you saying that as a matter of law, and Gibson, if Gibson did one thing to clarify the law, it said that the absence of a duty really equates to saying that this is a category of people who can never recover under any circumstances, period. I don't take you as taking such an extreme position in this case. I take you as saying there is a nuance. There was one duty and then there was another duty.
That is exactly my position.
Okay, but
You are correct.
if there was a duty at all, isn't that as far as the court can go as a matter of law, and then the content of the varying duties is left for the finder of fact?
Yes and no. There's a good lawyer answer for you. Yes and no. So
Well,
there
you
are.
actually answered with both of the answers that would have been appropriate, so congratulations.
All right. Well, do I get that Tesla then?
If you cross
But
I-17.
but in this context,
Yes.
which is a ruling on a motion to dismiss, isn't Judge Swan's question really, I mean, isn't the answer, yes, that's right, the judge's obligation is to decide whether there is or is not a duty. And if there is a duty, the case continues on to the next phase, which is likely some form of discovery to be followed by a motion for summary judgment.
I think then I misspoke. So let me clarify that. So let me comment first on the motion to dismiss. Yes, a motion to dismiss, it is not common that you're here on a motion to dismiss on a duty issue or a breach issue, but because appellant specifically pled many facts, and those facts really set this up, and no other facts are necessary if you admit the facts that are in those complaint, it did set it up so that the judge could make a ruling on duty. So that's one. Two is that when I talk about are there two duties, I am not saying that there is a duty in this particular case for Scottadale Christian Academy to Mr. Mauvis as a pedestrian on the roadway, because that's the status he held at that point. He no longer held a status of a business invitee, because the four corners of the property, he had left it. And if you look at the way the courts have interpreted status and special relationship throughout the course of the Court of Appeals and the Supreme Court, the four corners of the property, that's what they essentially acknowledge is where that business invitee, when we're talking about the status.
What if you're a magnet for those invitees, though? You basically create a situation where you absolutely know that you're going to cause people to come in. Now, some might say, oh, you just hit on foreseeability, so we can't consider that, right? And that might actually be correct when it comes to evaluating breach. But can we say as a matter of law that if you create a circumstance that's going to draw pedestrians into a dangerous zone, that you have no duty to those pedestrians?
No, I don't think you would go that far, but what I do think is important about what you said is this. What if you create a situation on your property?
Yeah.
That is what the duty is based on. I think appellant agrees with me. I loved his statement, and I think we should all hang on that statement in the reply, which says premises liability. The linchpin is whether a property owner has the ability to control what is going on, has the ability to control. Scottadale Christian Academy did not have the ability to control whether Mr. Mauvis chose to jaywalk, whether the driver of the other vehicle was going too fast. They only have the ability to control what is on their own property. And that is the linchpin of premises liability.
Yeah, but is that really correct? When you're starting a business and opening that up to the public, you have the ability to control where you locate the business, whether the business has appropriate ingress and egress, all those kinds of things. You could imagine just as easily a bottleneck that prevented from people from exiting orderly in the case of a fire. And then when they get just slightly off the premises, people are gathered in an unsafe manner. Are you suggesting that those considerations are irrelevant to the legal existence of a duty?
I am not, because I think your example goes to the issue of what is the duty to provide reasonable ingress and egress. Because if you've created a bottleneck on your property, then you have created a condition on your property that may have some effect off your property.
What if the bottleneck's just off the property and you know that?
Then you are imposing on a property owner a duty they do not have. A property owner is not responsible for, and the case law is clear, the property owner is not responsible for using his property in a way to protect the public, to protect pedestrians on the public roadway. What the duty is for the landowner to act in a way that does not create an unreasonably dangerous, and if there is a bottleneck, isn't that the duty of the city that's designed? Are you saying that now the property owner is responsible for designing the roadways?
Well, again, once you say what they're responsible to do, it becomes difficult because legal duties don't define that. But you did say very expressly that there are really two duties here of different character, and they change depending on where he is at the moment. And I think I can accept that. But I don't know how we continue the discussion then. Because if there are two duties and one of the two applies and we don't know what they mean because the finder of fact hasn't gotten to them yet, shouldn't we be waiting for a motion for summary judgment instead of a motion to dismiss?
I don't think you have to.
Okay.
Because I do think, again, that the appellant's complaint is specific and well-pled and does provide the factual predicate in order to make the decision on duty. If you look at the complaint and his status, and I've already talked about it, I'm sorry if I'm beating a dead horse here, but the status ends at the property line, the relational status. But if there is conduct on the property, then that creates a duty, and that is an addition to that. But it ends on the status. Am I saying he has no status at all? No, I'm saying he has no business invitee, licensee, or trespasser.
So help me then. You've got duty A, which is when he's on the property, and duty B, which is when he's off. And you've acknowledged that duty B can exist. Rather than asking you what duty B required the school to do, I would ask you, what is duty B based on?
Yes, I'm sorry, I interrupted you. My apologies. Yeah. So duty B, if using that, I am not saying there is a secondary duty here. What I am saying, his status changed. He is now a member of the public. He is now a pedestrian on a public thoroughfare. The question then is, what is the duty of a landowner? The duty of the landowner, and there is a duty. So okay. Perhaps
my question is why is the duty, not what is the duty? Yeah. Why is there a duty of the landowner once that status ends?
There's a duty because there is a potential duty if the conduct of the property owner is such that they create a hazard for the driving public. They're not responsible. The duty is not to create,
Now it's me.
to ensure safety.
Now
It's to
my turn
prevent.
to apologize for beating a dead horse. But you've got your thick binder there. We've talked about these cases. Didn't your answer just run afoul of Gibson and Quiroz? Because everything you just said was couched in terms of foreseeability. And that is the conundrum that those cases create. I understand. It's not an easy answer. But if you can't talk about foreseeability, then I'm struggling to understand why that other duty exists. And yet it seems that everyone in the room agrees that it somehow must.
Well, I think you have to look at some conduct. I mean, to say in a vacuum that we never have to look at any details in any way is in a vacuum, and it is not practicality. There is some decision-making that has to occur, just like in Nicoletti. You have to look at whether or, some conduct on behalf of both. And if that gets to the foreseeability or specific details, then we are in a conundrum, because we can never.
So what do we do with Quiroz and Gibson?
Well, I think that's what they were wrestling with. I do think that's what they're saying, is that in that particular circumstance, Quiroz did look at some conduct. There were fact specifics. There always has to be. So did Gibson. Gibson was about, giving out pharmaceuticals. Those are fact specific, but you have to talk about it in order for there to be any discussion about what is the status. Did they exceed the status? Just in Nicoletti, was the status exceeded? You have to look at the specific facts to do that in order to determine whether a duty has been extinguished or not. Otherwise, all we have every single complaint that is an allegation of, you're a property owner, I was a business invitee, there was a duty, there was a breach, we go to trial. I mean, that is not what I think
I'm not
Quiroz
sure.
and
I'm not-
Gibson were
It's
trying
not
to
that
do
simple.
here.
Yeah, I'm not sure that's exactly the way it works. Yes,
I
there's a
hope not.
There's a complaint, there's allegations, then there's another phase, it's called discovery. And then when discovery is concluded, there's an opportunity for the court to resolve whether the plaintiff can make their case or not. We're just trying to evaluate the first stage here. And I'm trying to also understand your view of status here, that the decedent was an invitee once his foot hit the boundary of the school, but not before. So what if he's standing in line at the box office and the line extends past the property line, but he's in line clearly for that purpose? Is he not an invitee at that point, if his feet are not on the inside the property line?
He is, and the reason he is
Because he's intending to go on that property.
is because
he's been implicitly invited into it, right?
it was within the scope of his invitation.
So what, if we follow up on that hypothetical, then, does it matter how fast the line is moving? Because if he's standing in line, in a slow-moving line, we agree he's an invitee. If he's walking toward the line at a faster clip, it seems your position is he's no longer an invitee.
Well, at some point, you do have to draw a line. If he's 2 miles down at his house and he's wandering up to does the duty extend down? Because if you take that to the logical extension, that is exactly what it was. You're now saying portal to portal. And I don't think that's what the courts intend, and I don't believe that the duty is that broad, or a business owner will always be responsible for any customer that's leaving their home to get to their house, is now responsible for their safety, portal to portal.
You're highlighting the wisdom of Judge Cardozo, but I don't know that it makes it easier to decide under our law. But I take your point logically, yeah.
Thank you.
Time is up. Please proceed.
Thank you. Bear in mind But when Mr. Mauvis walked to the table to get into the game where his wife and his child had already gone in, they wouldn't take a credit card. They said, well, can I pay afterwards? No. So he left the premises, a position of safety, crossed Tatum, got in his car, went to an ATM, came back with cash in his wallet, crossed the street again with the intention of paying the entry fee and benefiting the possessor of the property.
I'm glad you laid it out that way, because I'd like to know then, at what point in that sequence of events did he return to his status as invitee? Because clearly when is he at the ATM? If he got robbed at the ATM, I would probably say as a matter of law, we can say there's no duty there.
Yeah.
But at some point, you're saying he rejoins the class of invitees. I think both counsel actually agree that somewhere along that continuum, the duty pops up. What is the standard we're supposed to use?
Well, I think you've just stumbled. I don't mean to say it was inadvertent,
No, that's fair.
but I think you're now talking about proximate cause. I mean, I think that's what someone
think
would
I'm talking
apply
about
to try to
foreseeability.
analyze the distance at which they must be from the event in order to impose some sort of legal liability.
No, stumbling may be an accurate term, but proximate cause is not where I was going. I mean, I think what we're all talking about is the difficulty of reconciling our blinders to foreseeability that recent case law requires, and the reality that foreseeability infects all of our thoughts. And yet, and we all recognize, it seems that both counsel agree that there is a continuum along which a duty arises. You obviously have different views as to where that should be, but I'm left not understanding a legal rationale that could lead to predictable decisions in the future.
Well, let's talking about status for a moment. And if the relationship changes from business invitee to social guest licensee to trespasser, with respect to state roads, they've abandoned that, with respect to those who control the road, they've abandoned that status trespasser invitee business. It had a generic duty. If status determines it, what is his status on the road? Is he a trespasser to whom no duty is owed? When he's walking on a public highway with an intention to go to a business? I think this is not the case to cut that fine distinction and try to define those things. At this point, I mean, that issue was raised in the Stevens case, where the argument was made. Bassett contended it owed no duty to Stevens because it owes no duty to members of the traveling public on abutting streets. That's the status that counsel says now exists. And this court said, first, Stevens was not merely a member of the traveling public in relation to Bashes. He was a business invitee to whom Bashes owed a duty of care. Furthermore, several courts have concluded business duty to invitees may extend beyond its own property and so forth. Now, it may be that no one raised that issue in Bashes. It may be that you feel a need to make some new law on that subject. I shouldn't be reading things into it, but
Definitely don't read that feeling or need into this panel.
But no, it's a legitimate question and one that we obviously have thought about. And I just don't know, I don't know where you draw the line or whether that's something that the judge should decide in light of the framework. If I can digress just a moment to Markowitz.
Is this just one of those areas where we say, well, public policy suggests that there's sort of an expanded zone, and is that how you get there?
Well, as soon as you start defining those things, I think it. Well, let me talk to a framework just a moment. I think that may answer the question. The thing that was remarkable about Markowitz is it empowered the jury to do things that they had not theretofore done. When Justice Feldman made the distinction between the factual questions having to do with how a duty is fulfilled and the duty itself, it really reflected a greater respect for the jury's ability to sort those things out without a judge taking the position, we're not going to do this. And forgive the anecdote, but then 30 some odd years ago, I represented a lady named Cindy Law, teenager, who cut in front of a car went off the road, passengers were thrown out. A guy named Jim Harder was a city cop. And I defended her and said, you should have had a seatbelt on. That went to the Court of Appeals, went to the Supreme Court. It's law versus Superior Court. And the whole premise of that was based on Markowitz. We said, because the law before that said that you have no duty to buckle yourself in as a matter of law. It's unforeseeable injuries and so forth. And drawing on Markowitz, the argument in the Supreme Court was this is something that a jury is perfectly capable of deciding. You can't decide that as a matter of law now and say that defense doesn't exist. And then the seatbelt defense came thereafter. Now, the point of that is that there are some things that the jury is perfectly capable of deciding once they have all the facts in front of them. The court need not be a guardian and a determiner of when someone ceases to be an invitee based on proximity to the premises.
So it would be your position then, tell me if I'm wrong, I'm not trying to put words in your mouth, but I think you're saying that because there is at least an invitee character to the relationship, any variation in the seriousness of that duty is a question of fact that can be resolved by the jury, and we shouldn't concern ourselves with rigidly defining duties as a matter of law.
I wish I had said it that well. Yes.
Well, but I guess my concern with that, though, is then we go to the hypothetical. So now he's sitting at home contemplating going to the church and gets hit coming out of his driveway. I mean, clearly none of us would say that there's a duty there as a matter of law. We're not going to rely on the jury for that, right?
I think that's so. Yeah.
Okay. So again, we're left with this continuum, and at some point the duty arises, but does any Arizona case tell us how to decide where that point is? And I'm asking not to confuse either one of you, but
sure.
I think it's a genuine open question in Arizona law.
I think it is. I'm thinking about the little boy chasing the basketball on the street in UD. Whether it was reasonable to put up the fence was something that was reserved for the jury. The duty didn't change just because he went off the premises. I don't know how one resolves that deeper question of how you draw the line, but I don't think you can do it in this case and simply say we'll affirm the judge's decision, even though she didn't draw the line either, just because he's off the premises and maybe comparatively at fault.
When we look at duty, and the latest restatement of torts encourages us to adopt everyone owes everyone else a duty. We haven't done that. What we've done is say, Judge, you decide if there's a duty owed, and then we can proceed. So the court is really acting in a gatekeeping function. If you don't have the relationship, you can't move forward to the rest of this. And the court poured your client out on the relationship issue in regard to the school specifically. So when we look at what the duty is, you've got the edge of the property. We all agree if he had been injured on the property, there is a duty. Then Judge Swan asked you if he got injured at the ATM or at his house. We don't think there would be a duty.
Yeah, that's remote, not proximate.
I get that, but that
Yeah.
has nothing to do with, we're just looking at the relationship between the people. So how do we get to the point where that business invitee extends out a mile, 2 miles? How does the judge ever get to the point where they can cut off that duty relationship and grant a motion to dismiss if we accept what you have presented as the premise of duty?
This is a far more scholarly approach to things than I had thought about. I mean, you're asking me to kind of thinking out loud. How does one draw those lines when it hasn't been done before? And I guess I have to fall back on the wisdom of a jury to determine it. And I understand that you can't abdicate your gatekeeper role, but there are some cases where it is so remote that you're comfortable in doing so, and some where it's either the time or the distance is kind of murky, and maybe that's the time to decide, well, I can't decide that. I don't have enough information. Let's go try the case. They can get an instruction on whether duty will extend that far. They can make that argument to a finder of fact.
All right, anything further? Very rousing argument. Torts are squishy. I would like them to be firm, they are not. So I thank you both for your arguments and your wonderful mastery of this very squishy topic. We will take this under advisement and issue a written ruling in due course.
Okay.
Thank you.
We are at recess.
Thank you.